Good morning. This hearing session is now open. I trust everyone can hear and see me okay?
Yeah.
Okay, today's session forms part of the examination of the Whitley Local Plan Part 2. My name is GJ Fort and I am the inspector appointed by the Secretary of State to conduct the examination and to report to the Council in due course. As ever, the format of the hearing is a structured and focused discussion that I shall lead. So before we continue any further, could I ask firstly for the representatives of the Council to introduce themselves, please?
Morning, sir, and welcome back. Wayne Beglin of Council for the Local Planning Authority, and with me today I have Mr. Longley, Mr. Ellis, Ms. Nash, Ms. Dove, and Ms. Knowles.
Thank you, Mr. Beglin. And if I could ask others on the call to introduce themselves, if I could ask, starting with Mr. Chapman.
Morning, sir. Jesse Chapman from D&M Planning.
And Ms. Windsor.
Good morning. Emily Windsor from Falcon Chambers on behalf of Mr. and Mrs. House.
Thank you. Mr. Roberts.
Morning, sir. Christopher Roberts, Boyer Planning, acting for Ashire Land.
Mr. Burden.
Morning, sir. Tim Burden from Turley on behalf of Fakeham Homes.
Mr. Moores.
Good morning, sir. Richard Moles of Council on behalf of Waits Developments Limited.
Mr. Good.
And sir, Matthew Good from Pegasus Group on behalf of William Lacey Group.
Mr. House.
Morning, sir. Tim House on my and my wife's behalf.
Ms. Ashton.
Morning, sir. Judith Ashton on behalf of Waits Developments.
Thank you. Mr. Neame.
Good morning, sir. David Neame from Neame Sutton on behalf of Bewley Homes PLC, Reside Developments Limited, Monkhill Limited, Redwood Southwest Limited, Crown Horn Castle Estates.
Thank you. And I've got, well, the name's Mr. Lulham, DHA Planning.
Morning, sir. Emma Hawkes and Paul Lulham from DHA Planning on behalf of United Learning.
Thank you. Mr. Wood.
Yeah, good morning, sir. Michael Wood, WSP, here on behalf of Ptarmigan Land and Bewley Homes.
Thank you. Mr. Munton.
Good morning, Andrew Munton from Reside Developments.
Thank you. Mr. Banner.
Good morning, sir. Charlie Banner QC for Monkhill.
Thank you. I've got Mr. Lawson. Okay.
So Mr. Lawson's my client. I don't think he's likely to speak, but he's logged in anyway.
Okay. Okay. Thank you. Thank you for the clarification, Mr. Banner. Okay. A reminder that the programme officer is Charlotte Glancy, who is the main point of contact for the examination and should be copied in to all correspondence. The hearings are being filmed and live streamed. I take it everyone here is comfortable with that. Documents under examination of the Regulation 19 version of the Local Plan Part 2 and its addendum, which was submitted for examination on the 22nd of December 2021. Prior to submission, Regulation 19 consultation took place on the documents, and I have copies of all representations received at that stage and will take them into account. I've produced guidance notes for the examination and also identified matters, issues and related questions relevant to this specific session. I have received statements and related material from the council and from others on the specific points, and this material is available on the examination website. I intend to take mid-morning, lunch and mid-afternoon breaks insofar as possible in accordance with the timetable. A reminder that I am tasked with considering the soundness of the plan in accordance with the National Planning Policy Framework and also whether it is legally compliant. The hearings are intended to assist me in that regard, and in submitting the plan, the council considers that it is a sound one, and this is a starting point for the examination. So if you are challenging the soundness of the plan, then you have to explain why and what changes might be necessary that will make it sound. I have read and will take into account the hearing statements that have been prepared and also the original representations that were made, so there is no need for these to be substantially repeated. Instead, the aim is that the discussion moves on from those documents and deals with specific questions that I have or areas where further clarification or explanation are required. At times, I may ask for a more general contribution or a summary of your position. In order to test the plan for soundness and legal compliance, I will need to ask questions. You will have seen that I've already been doing this in preliminary questions and correspondence with the council, in the published MIQ documents and in earlier hearing sessions. And both the council and other participants have responded to these. So the questions will continue today. However, anything that is asked should not be taken as demonstrating a particular predisposition on my part. I will normally start a particular topic by asking the council for responses to questions I have before indicating that I wish others to comment. If you do wish to comment, then please indicate this by using the hands up tool in the Zoom program. I may also invite contributions from you on specific points where I think this may assist the examination. Participants will have to make sure that they are unmuted when speaking to me, but muted at all other times. It would assist me if the council could keep their camera on at all times, and I'll keep my camera on at all times. But if others could just turn the camera on when they intend to participate, that would help with the live streaming of the event. If any of those joining us experience any technical difficulties, they should make contact with the programme officer in the first instance. If in the course of discussion you wish to highlight certain parts of your statements or other documents that form part of the examination, then it will be helpful if you can provide the reference. It is open to the council to propose further changes to the plan, and I would ask that they keep a record of possible changes that arise during the discussions. Any changes that would constitute main modifications will be subject to future consultation. The examination remains open until my report is submitted to the council. However, no further representations or evidence will be accepted after the hearing sessions have finished unless I specifically request otherwise. There will be a short session at the end of today to ensure that any suggested modifications or other additional items suggested during the course of discussions have been adequately recorded. And at the end of today's session, I will indicate the likely timescales of the next phases of the examination. Are there any questions at this stage about any of the procedural aspects of the hearings? Okay, in that case, if we can now move on to the council's opening remarks for this session, please.
Well, sir, thank you. And once again, it is my pleasure on behalf of the council to welcome you and the other attendees back to the examination hearings for this resumed day. And so the council is grateful to you for your continued approach to the examination and for the opportunity to put forward further statements covering today's three remaining issues. And so, as you may know, in the background, the council has been working on its proposed schedule of main modifications, which is largely now complete. And so in relation to today, the council will take a steer from you as to the extent it's necessary or useful to rehearse points previously made in relation to today's topics. But in general terms, our approach will be to try and avoid repetition of the material already provided. And in that respect, we note the emphasis that you've already provided in relation to this hearing being based on 7 focused questions to address additional evidence submitted during and since the original hearings. And so just by way of recapping some of the background for the wider audience, the council, as you know, has indicated before the local levels of pressure for development and the historically high levels of housing achieved over the last 5 years, and completion of part 2 of the local plan so that the council can continue with a genuinely plan-led approach in line with the strategic framework established by part 1 of the local plan is important to maintaining those goals. Part 2 of the local plan, of course, also proceeds against the mosaic of local neighbourhood plans that have already been discussed through this examination. And it is perhaps worth briefly reiterating that the council needs to decide by February of next year, that date being 5 years from the adoption of part 1 of the local plan, if, when and how part 1 should be updated. And at that stage, the review will take account of factors including any new MPPF or government guidance, updated evidence, and the council's strategic priorities, including the strong commitment to addressing the challenges of climate change. And so the council's view remains that, subject to any necessary main modifications, part 2 of the local plan does the job it was intended to do, enabling the borough to accommodate much needed development in the most appropriate locations and of the highest possible standard of design. Thank you.
Thank you, Mr. Beglan. So now we move on to discuss in more detail the housing requirements, supply and allocations aspects, which were the subject of matter 2 of the focus questions that I published last month. So I did prepare an agenda for this specific session, which I think was circulated yesterday, but just to set that out in brief how I intend to take this discussion, if you haven't had the chance to see it. I think firstly we'll look at the justification for the housing requirements set out in proposed main modifications for the settlements named in LPP2 firstly. Then we'll go on to the justification for the anticipated rate of development for LPP2's allocated sites as set out in proposed main modifications, and that takes forward discussions on the basis of responses received to questions 2 to 5 of those focus questions that are circulated. And then finally, we'll go on to any other matters on the council's updated housing trajectory and related information. So, whilst I have a number of additional questions following on from the statements and related material that has been received, I hope the session will also provide an opportunity for participants to make comments on the evidence that has been recently supplied by the council. So in opening this discussion, I reiterate that the positions of the council and other parties on the scope of the Part 2 plan in terms of the 5-year housing land supply situation and matters relating to the geographical focus of its allocations are well understood, and I will not be asking any further questions on these specific points, and neither do I expect any further submissions on those topics at this stage. So I'll start this session as usual with an opening question for the council as to whether the requirements for Whitley and Hazelmere as included in suggested main modifications are justified.
Good morning, sir. Yes, we do think that the housing numbers for Whitley and Hazelmere are indeed justified, and we've set out our response about that in our response to the matter 2 questions that we sent to you a couple of weeks ago.
Thank you. Just a note for people watching, you might see me looking over the top of my screen sometimes. I'm still listening, it's just I've got a screen on the wall where all the documents are, so that'll explain that. So if we could move on specifically to Whitley and Milford. So a note has been provided, Mr. Beglin, in relation to the covenant position relating to the golf course. And I've also been supplied with an opinion on this matter from Ms. Windsor on behalf of the houses. Now, firstly, Mr. Beglin, just to clarify, although I did invite a statement of common ground, I take it that one isn't being progressed at this stage on this matter.
Sir, that's right. Mr. Longley can take you through such factual update as is available in that respect, perhaps after I've made some remarks in relation to the notes that are before you, but taken in whichever order is convenient for you.
Yeah, if we could take the note first, Mr. Beglin. So in terms of that note, how do the assumptions within that note inform the trajectory that's now anticipated for the site? And have you got any reflections as well on the submissions of Ms. Windsor, if you've been able to see those, Mr. Beglin?
So yes, I have had an opportunity to see those, and sir, as you may recall, in relation to the golf course, of course, it's programmed into the trajectory as a developable site towards the end of that trajectory, starting in 2027 and moving forward from there. And so everything that I say is sort of prefaced on the fact that that is the program timing as far as the council is concerned. And so if I take matters in a certain order, just so that you have a route plan for where we're going, and I'll try not to spend too long on any matters that you think are really perhaps beyond the scope of this examination, because they're matters for somewhere else, if I use that language, and more specifically for the upper tribunal. But in relation to what I'm proposing to say, first of all, some overarching points, then to look at the position at a higher level in relation to whether or not this site is developable, and then thirdly, to take you by way of recap through my notes and all those of the Borough Council, and you'll recall that there are now 3 of those notes, and the third is intended to be supplemental to the first 2. Then perhaps to take some points that have been made in other representations, not the focus that Mr. House has provided and that Ms. Windsor has provided, but there are some other observations in the other representations. So I'll deal with those perhaps more briefly. And then I will spend just a little time dealing with the more specific points that have been made on Mr. House's behalf. So taking things in that order. So first of all, in relation to the overarching points, as you will know from the contents of the PPG, and this was something that was set forward in the earlier 2 notes on behalf of the authority, covenants are not normally a matter for planning control. And this is because there are various ways potentially of overcoming restrictive covenants that are otherwise legally enforceable against an individual or body that wants to develop land. And it's not normally considered appropriate within the planning process to delve too deeply into those alternative jurisdictions. And we suggest that that is part of the reason why the test of developability has come about with the definition that it has, and certainly whether or not that's as a result of these kinds of issues, it certainly helps us here because we know what that definition requires as a result of the MPPF. And it's worth pausing perhaps to reflect that when we know that covenants aren't generally a particular focus of this part of the planning process. It may be that in this case, the reason that the covenant has come into such sharp focus, in particular in Mr. House's submissions, is because once that covenant is stripped out, there's no suggestion of any technical reason why this land can't come forward, no real suggestion of any other substantial impediment. And so perhaps that's why more naturally the focus has moved to the covenant and its likely impact and efficacy. So in terms of whether or not the land is developable, so we've set that reference out in our notes. You're well familiar with it. Plainly, it's a more relaxed definition, if I can put it that way, than the definition of deliverability. And that's true in relation to a number of limbs of the test. But for present purposes, perhaps the most important point is that certainty is not required. It is the reasonable prospect of the land becoming available at the appropriate time. And here we have a site that has now essentially full planning permission. As I say, no suggestion of any other important impediment for it coming forward. And you have detailed notes. I suggest that they're detailed in the sense that they're sufficient for a proportionate evidence base from the local planning authority. And so we say that those notes are sufficient for local plan purposes, and they explain why the council remains of the view that there is at least a reasonable prospect that the covenant can be overcome. And so, sir, if I turn therefore briefly to those notes, and so do you have access to those notes?
Yes, Mr. Beglin.
Grateful. And so, sir, in relation to the first note, we set out there the statutory provisions that are engaged and how such matters are commonly resolved, and indeed the things that the upper tribunal must take into account, some of the things that it must take into account. And so you will recall as you go back over this note that the council has been consistent in its position that there is a compelling or overwhelming case, we say, in relation to the public interest concerns that arise here. And we set them out early in that first note. And then in the last paragraph, just to refresh everyone's memory, and so that you note that it's there, of course, we noted at that early stage that as a matter of last resort, there are the now extensive powers in section 203 of the Housing and Planning Act. But as you know from our most recent note, the council's present preferred approach is not to rely on that power, but for the matters to be dealt with by way of an application to the tribunal, as it appears, at least in its early stages, will be necessary. So moving on to note 2, we set out more of the history there, and that note, you may recall, was responding quite specifically to an opinion that was produced for the assistance of Inspector Bore. So quite a lot of the detail of that is really substantially in response to that note. But at paragraph 5, we note the nature of the planning policy guidance that Mr. and Mrs. House were then relying upon, and the, as it were, the relative lack of focus in relation to covenant issues by themselves. Turning to the third and most recent note, and so this note was produced just a few days before Miss Windsor's advice. So the note is the 19th of August 2022 from its last page, and in paragraph 2 I take you back to Inspector Bore's report, and this potentially is something of significance, because if you've had a chance, I know you've read that report a significant number of times already, but if you've had a chance to read it side by side with the note, then what you will see is that, of course, you'll recall that Inspector Bore, of course, asked himself this question about whether or not there was a reasonable prospect of the covenant being varied, modified, or discharged. And he answered that question. He very clearly concluded, in light of some specific circumstances that he referred to, and of course, when we come on to discuss what's been said on behalf of Mr. House, it's important to record how fact-specific these cases in consideration of the public interest inevitably are, because here was Inspector Bore reaching a conclusion in relation to the very specific circumstances that arise here. And he drew attention to the need for housing to be made available, the strategic exceptional circumstances for greenbelt release, and other features in reaching that conclusion. He noted the age of the covenant, concluded the allocation was sound, and in particular, in a phrase that you certainly won't find, as far as I can ascertain, in any of the reports that have been relied upon any of the cases that have been relied upon to support Mr. House's position, a conclusion by Inspector Ball that this was a very well chosen site. Its release from greenbelts justified by exceptional circumstances. Now, I've set out after that in the note what happened by way of challenge to LBP Part 1, but all of those challenges ultimately fell away or were dismissed. And so the council remains of the view that the land is developable, paragraph 5, and I refer again to the absence of apparent impediment, paragraph 6. Turning to the factors in support of modification, we've set them out there, but you'll see that they're essentially largely common with what was set out in the first note. So again, the council's maintained a consistent position there. And those are the central features that are relied upon to support the strength of the public interest that we say exists here, that the upper tribunal will ultimately consider. And so I don't read those out, they're there, and you have doubtless reread matters. And then paragraph 10, again, reference to section 203, but setting out the council's current approach in that respect. And so moving from that to what has been said on behalf of Mr. and Mrs. House. And here I do say that context is king, or at least very important to considering what's being said on their behalf. And it's been said at the highest level that no statement is ever made acontextually within a judgment. And that certainly applies to what we are looking at. Some observations by reference to paragraph numbers and then cases in Ms. Windsor's advice. Paragraph 1 puts the prospects of successfully defeating the application at 70%. That there's an obvious other side of that coin, and that's that even on the assessment that comes in support of Mr. and Mrs. House's position, 30% is said to be a prospect of the application succeeding. Secondly, and importantly, in the authorities that have been referred to, there is no case which is close on its facts to this one, and in particular, which mirrors the various factors that we say are important in assessing the level of public interest that arrives in this case. And a third general observation, it would be interesting to imagine the reaction of various planners that are remotely in the room with us now. If I had said, in general defence of this plan, there's been a housing shortage in the southeast for however many years, but let's not trouble ourselves about that. That doesn't go to the public interest. Here, specifically in Waverley, the facts are well rehearsed about the level of need locally and the need for affordable housing and so on, and you have all of that information. We agree, and so it shouldn't be controversial, that development along the lines that the golf course land is proposed for would be in breach of the covenant as it stands. So that's why the need to test it against the public interest test and other potential grounds for modifying the covenant arise. Paragraph 20 of the advice, if we can just take that up, and so bear with me a second. Refers to what's described as an ordinary position in relation to the grant of planning permission being persuasive evidence that a proposed user is reasonable, which is one of the tests that needs to be satisfied on the way through section 84. And in relation to that, we simply say that this is not a case where the grant of planning permission was a close run thing. The site was allocated and is proposed to come forward for the reasons that are so clearly set out by Inspector Ball. And so there is no reason to think other than an upper tribunal will find that this is a use which is a reasonable one of the site. And then turning to the authorities that are relied upon, the first is Lamble and Batacci. And so I pause here because what I'm going to propose to do is just to give you a few highlights that I say indicate important differences between these cases and the circumstances that you're confronted with. But if Miss Windsor or any other participant thinks and you consider that it's appropriate for you to have these cases before you, we have absolutely no objection to that, so that you can check everything that I'm now saying by reference to those cases. But we do wonder if that's sort of necessary in the circumstances. But as I say, if anyone else thinks it's appropriate, we have absolutely no objection. Now, in relation to the Lamble case, that involved a single bungalow and plot. It was to do with a replacement house with a large garage and summer house, so 3 additional buildings, 2 of which were to be erected under permitted development rights. And one of the things that was said that's important to that case is, if the tribunal doubts that the planning permission was carefully considered and instead came close to regarding the terms of the grant as irrational, the weight which the tribunal felt able to give the permission must inevitably be diminished. And I just say that one can make the clearest possible contrast between the planning considerations that have gone into consideration of this land compared to the land that the tribunal were considering there. And interestingly, I don't know if these cases are going to be put before you, but if they are, you'll see that in that case, there was an assessment of compensation. Because one of the issues that's been raised by Miss Windsor is about whether or not compensation could be affected in this case. If you were to look at these cases, you'd see that in a significant number of them, the issue of compensation has arisen and various methods for assessing compensation and dealing with it have been addressed. Paragraph 28 of the advice deals with residential amenity, and we say in this case experienced officers of the authority have taken a view about that and whether or not there are, for example, unacceptable impacts in relation to amenity. And you'll note in paragraph 28 that Ms Windsor appears to accept that the correct comparison for these purposes is between the potential presence of 27 houses as against 190 on the site. Paragraph 29A simply observe that this is not overdevelopment as far as the authority is concerned. We say it's development at a relatively modest density. And at paragraph 30, of course, it's accepted, as it must be, that ultimately these kinds of issues are issues for the experts at the upper tribunal. And so moving on to the few authorities, well, there are a few authorities that Ms Windsor has relied upon in the public interest analysis. The first, re Collins's application, case of 1974. In fact, the reference there appears to be to a case called SJC Construction Company Limited and Sutton. And if the authorities are going in front of you, we'll simply ask for that to be included, because there are a couple of intriguing things about that case. In the SJC Construction Company case, in fact, the application was allowed. That involved the property that's relatively well known if you're local to those parts anyway, Whitehall in Cheam in Surrey. And it also is of interest because Douglas Frank at Queen's Counsel was the judge there, as what he was the judge in Collins as well. And he allowed the application in that case based on the idea that enforcing the covenant was contrary to the public interest. The case went up to the Court of Appeal, but not on that point, only on the appropriate measure of compensation. And in allowing the application, he looked at the fact that there had been planning permission for the block of flats. He looked at the adverse impact on Whitehall, concluded it wasn't serious. And he looked at the scarcity of land available for building in the whole of South East England, including Cheam. So insofar as there are suggestions that you can't look at the housing position either more broadly or more specifically to a local authority, here's one example where in fact those things were taken into account in allowing an application to be successful. If we turn to Collins itself, just a few short points on that. That concerned land in Fleet in Hampshire. There were 15 objectors to that proposed application. The application was for 32 houses in an area where only 4 would have been permitted on a construction of the covenant. housing concerns that were articulated in support of the public interest, and this is a feature of the various cases that have been referred to, was at a much greater level of generalisation and abstraction. And it happened in circumstances, in fact, Collins was a bit unusual because of the date at which it was decided. It was held that most of the evidence that the applicant wanted to rely upon in terms of material that supported the development plan, supported housing need locally, but wasn't actually admissible under the civil evidence rules that then applied. This was a case, as were apparently most of the others relied upon, that didn't have the support of the local planning authority. And the books that have been written on this topic indicate that, in fact, whether or not the local planning authority supports a position can be significant in these circumstances. And you know what the local planning authority's position is in relation to this land. So that's Collins. The next case is Rebase Limited, the application there. The context was entirely different. That was for a trunker park for loading and unloading very large articulated lorries. The tribunal, as we know in our case, will determine whether the planning permission is a reflection of the public interest. In Rebase's case, the quote that appears in Miss Windsor's advice under that paragraph continues with these words. Many planning applications will have got through by the skin of their teeth. So again, the context of what's being said is in the acknowledgement that there will be some cases where planning permission may have been granted on a very fine balance. And that, of course, will have an influence on how the upper tribunal approaches these issues. We say again, at least arguably, we're at the other end of the spectrum from that kind of situation. Osborne and Easton is next. That was a series of estate covenants with a restriction precluding additional dwelling numbers. So quite different from what we've got here, where there was a preclusion. There were some 63 objectors, and the proposal was for 2 blocks of flats on 2 plots, 20 flats on one and 12 flats on another, with 32 garages and 16 parking spaces. And the planning considerations in play were, again, at that very high level of abstraction. It was said that there was support for higher densities of development as desired by central government, and you can pick that up from page 255 of the PNCR report. Re Hunt's application is next. That was another mutual covenants case on an estate for 54 houses. Objections were lodged by, amongst others, the relevant borough council, Thamesdown, and the residents of 14 houses. And in that case, one additional house had been constructed pursuant to a planning permission, and it had been built so that it was in advance of the building line that had been imposed by the relevant restrictive covenant. And that was the issue that essentially arose in that case. But again, if we look at the general observations that were made in that case, 3 interesting observations arise. Firstly, it was said that the inspector's views in granting the planning permission command respect. That's page 135 of the report. Presumably, the upper tribunal, well, I say presumably, we know that the upper tribunal will take into account the views of Inspector Board, doubtless any views of your own, and the views that are expressed in the grant of the planning permission in considering the issues in this case. There was a note there about the acute scarcity of land available, and the submissions on public interest were essentially restricted to having a single house empty or pulled down. So again, the factual context really very different. Havering College involved college land that was surplus to its educational requirements. Some 78 objectors, 71 of whom were represented at the tribunal. That involved planning permission on an area of brownfield land with a proposal for housing and some, including some affordable housing, but it was again tested against what was then PPG 3 in its 2000 variant. And the point that was being apparently articulated, as far as we can tell from the report, was again about those generalized policies rather than something that's more specific. And as it happens, the covenants in that case imposed a substantial number of other restrictions on development. Hawkins, 2015 case, context again, single bungalow, a restriction as between 2 plots, and the action was by the original covenantee, in that case, Mr. Park, And the main point that appears to have arisen again was to do with the general promotion of higher density development. Now, O'Reilly's application, potentially more important because this is the case that Ms Windsor relies upon to support the submission that paragraph 39 of the advice note, in general, the tribunal tends to require evidence that there are no alternative premises of which the relevant public interest could readily be met before it can be satisfied. And that's what O'Reilly has put forward as a proposition for. We say, if you want to have a look at that case, and you don't necessarily want all of the others, we say if you look at that case, you'll see that it doesn't actually support that proposition. And we say that bearing in mind the context of that case and the way that the observations were made. And the context was that this was land sold by Rochester upon Medway Council, subject to a restriction not to use it for other than car parking. So it's car parking case. Very little interest had been shown by anyone in relation to the site when planning permission was being sought. No objection save that of the local planning authority. And the case was decided. This is critical to understanding whether it supports the proposition that it's said to support. The case was decided on the basis that the land didn't secure any practical advantage, which is an alternative potential test from the public interest case. And so on page 489 of the report, the way that the judge dealt with the issue of the evidence available there was to say, I had no evidence as to the availability of housing land in Chatham, and therefore I cannot be justified in concluding that withholding the site from development for 6 dwellings is contrary to the public interest. So that was a case that was formed essentially in the absence of evidence about that point. And we say the position is entirely different there. So for those reasons, we say, and that we can properly put forward and maintain the view that there are at least reasonable prospects of the covenant being discharged when you look at the particular facts and circumstances as already have been identified by Inspector Bore, and we have his conclusion. And it's against that backdrop and with potentially the support of SML and or Carla Holmes, I'll let Mr. Longley speak to this in a moment, that we say that the overall position in notes 1, 2 and 3 shows that the council has done enough to provide a proportionate evidence base to show that the covenant can be overcome and that the site remains a developable. And so I'm conscious there was an awful lot there. We will have the benefits, I think, of transcripts or looking back over the recording, but if it would help you for that to be reduced into a note, pretty much verbatim from what I've said, then that's something that can additionally be done. But to deal with other factual matters, if it's a convenient moment, I'll hand over to the rest of the team.
Thank you, Mr. Beglan. I just want to probe a little before you do hand over to the rest of the team in terms of timing of an application to the tribunal. So as I understand it, the planning permission, the date for that was November last year. Is that correct? So is it reasonable then for the, and I mean, there's another point that we'll go on to discuss later that's been picked up elsewhere about who would be responsible for progressing the application. We've seen that in some hearing statements, but whoever's responsibility it is, you think it's a reasonable in terms of timing for them to wait until they've got the planning permission in place before they progress the case, you know, on the public benefit side of things?
So yes, absolutely, because a number of things have happened in relation to this land that we say have strengthened the public interest case very substantially, and they're the things that we've attempted to summarise in the notes. But it is first of all the fact that the land has been taken out of the green belt as part of the strategic approach in part 1. It is a strategic site in part 1. We then move forward to look at the way that the planning permission was granted and that the remaining matters were dealt with. All of those now have planning permission. And of course, it's at that stage that the case to the upper tribunal, regardless of whether you ultimately think it's a strong or weaker case, there can't be any sensible doubt that those features strengthen the case wherever you started from in your assessment of it. And so it's entirely common for those who wish to develop land to wait until they're in precisely the position that the owners and the party with a conditional contract are now in. And again, you can see that in the reported cases. In the list that I read to you, you will have picked up that in a significant proportion of the cases, I think probably in all of them, or virtually all of them, there is a planning permission in place. And the statutory scheme specifically makes provision for those kinds of things to be taken into account.
Okay, and just to clarify on the section 203 of the Housing and Planning Act, and noting that it's not the council's intention to use that power at this juncture, but in terms of the mechanics of that and timing of an action pursuant to that act, just in general, how would that be likely to pan out, Mr. Beglin?
So in terms of what would need to be done in order to comply with section 203, there are various requirements in subsection 2 of that act, which is the presence of planning consent. So again, that's a prerequisite. There is then the requirement for the land to become vested in or acquired by the specified authority. So there would need to be a transfer for those purposes, or for the land to have been appropriated for planning purposes under section 246. Either of those that plainly require decision making by the local planning authority. It has to be land that the authority could, in theory, apply under compulsory mechanisms, and I doubt there's much debate about that here. And then lastly, the fourth condition is that the building or maintenance work is for the purposes related to the purposes for which the land was vested. And here that plainly would be so, because the reason for the vesting would be so that the planning permission could be carried into effect. So there are decisions that would need to be made by the local planning authority before section 203 could be brought into operation. And so again, I don't want to burden you unnecessarily with detail, but if you wanted a commentary to section 203, as you may already know, it appears, of course, in Planning Encyclopedia. And the reference to that is 2-7060, and the commentary appears immediately afterwards.
Thank you, Mr. Beglin. So if we could have Mr. Longley's responses.
Yes, thank you.
Yeah, good morning, sir. If I can just explain how we responded to your suggestion that we might consider a statement of common ground with the promoters and tell you where we've got to with that. We liaised with Shoesmiths, who are acting for Stretton Milford Limited, and had discussions around points that could be agreed. In the event, we were defeated mainly by time in getting something to you by the deadline for evidence. However, there are some straightforward factual points that Stretton Milford have been very happy to agree to, and in addition, they've also confirmed to us their position in relation to the covenant, and are happy for us to share that with you. So I'm afraid there will be a little bit of duplication with what Mr. Beglin has told you, but if I could just quickly run through those. And at the outset, if I could apologise to participants for any confusion caused by the fact that we had been anticipating the statement of common ground, and therefore Mr. Beglin's note did make reference to that, but obviously at the end of the day, we haven't produced a formal statement. So in response to your question about whether the golf club site is deliverable for the purposes of the MPPF, our response is yes, it clearly does meet the definition of a developable site, being in a suitable location and with a reasonable prospect that it will be available and can be viably developed at the point envisaged. And the point envisaged, as you've heard, is the latter 5 years of the plan period. And in our trajectory, we've shown 30 completions in 2027, 28, and 40 per annum thereafter. That I should say that's the council's position. That isn't. We haven't gone into that level of detail in terms of the agreed points, but we think that is a realistic and cautious trajectory, which gives a 5-year period to resolve the outstanding matter around the covenant. So in terms of the factual points, which I'll just trot through, I'll refer to Stretton Milford Limited as SML. They own the site, and Carla Holmes has a conditional contract to purchase it. The site is allocated in the Part 1 local plan as a strategic housing site to accommodate around 180 homes, subject to several criteria, and that's, of course, policy SS6. SML have secured outline planning permission for a scheme of up to 200 dwellings in February 2019. And Carla Holmes subsequently secured reserve matters consent for the erection of 190 dwellings in November 2021. And it has subsequently been working with the council to discharge the planning conditions. And we're advised that Carla Holmes is ready to implement the permitted scheme. Obviously, you know that the site is subject to a restrictive covenant, which doesn't prohibit land, but prohibit development, but would restrict the level of development quite considerably. Our view, and that of SML, is that this amount of development on an 11-hectare site would not be the most efficient use of land in meeting the needs for homes and other uses, as set out in MPPF Chapter 11, and particularly paragraph 125, which stresses the need to make most efficient use of land. The acceptability in planning terms of developing the site has been established through the statutory development plan and the subsequent permitted scheme. And so in our view, as Mr. Beglin has set out, prohibiting the delivery of that permitted scheme by simple reliance on the covenant would be contrary to the public interest. So those are the main factual points. In addition, SML have confirmed to us and have said they're happy for it to be shared this morning, that they consider, on the basis of legal advice, that they have a strong case for securing the removal of the covenant through an application under Section 84 of the Law and Property Act, albeit they recognise that the tribunal decision inevitably carries an element of uncertainty. They say that work is currently being carried out to support the application, including the preparation of valuation evidence. And finally, they confirm that SML have at all times remained open to dialogue with Mr. and Mrs. House to try and secure a negotiated settlement, and they will continue to seek this. So I think so. That's the main factual and other points that I'd wish to convey.
Thank you, Mr. Longley. There's some points on the implementation of the planning permission that I think Ms. Ashton raised in her brief statement for these hearings, but I want to bring in Mr. House now just to respond to those points we've heard about the potential the section, I don't remember which section, the Law of Property Act.
Section 84.
Yeah, implication.
Morning, sir. Thank you very much indeed. And just to preface this, I think perhaps I'll make some initial comments and remarks, if I may, and I'm going to do them principally by reference to Mr. Beglin's third note. And then, if it's convenient to you, sir, I was going to ask Emily Windsor to deal with the particular points in relation to the case law and any points on her note. And you already have, and you've referenced it, her full written opinion as an appendix to our further hearing statement, which was dated the 25th of August. The points that I want to make are not going to duplicate, but I think they do reinforce the submissions that we've already made in writing before the examination and the submissions that I made orally on the 12th and the 21st of July. The further statement, as you appreciate, and counsel's opinion, Emily Windsor's opinion, were drafted without sight of Mr. Beglin's additional note on the covenants, which was dated the 19th of August, but wasn't available to anyone until the 31st of August. So, sir, my preliminary points, and there are a few of them, and I apologize for the time that it'll take, and then I'll move on to the specific points of Mr. Beglin's note. Throughout this examination, and really despite the controversy surrounding the MGC site, I think it is notable that you have heard nothing from the owner of the site, that's Stretton Milford, or from Carla Holmes. And I was going to make the point that that remains the case today. There's been no representative, no written representations, and nothing produced by WBC derived from the owner or from the developer. I'd have to caveat that with what, just in passing comment, I think is a little unsatisfactory, actually, is a commentary from WBC about comments, discussions they are said to have had with Stretton Milford's lawyers. But it does remain the case that despite your further questions inviting WBC to pursue a statement of common ground, there is none. I noted the observation that they've been defeated by time, which surprises me a little bit, since we've been making these points since May of this year, fairly consistently saying, possibly even in some people's views, sort of provoking, where's the advice? Where's the evidence? What's happening about this application? And I think it is curious that there's no statement of common ground, because Mr. Beglin's updated note plainly was based on some sort of statement of common ground, because he refers to it twice in his note, once in paragraph 1 and then once again in paragraph 9c. So we inquired about this on Friday and were told the council has not submitted a statement of common ground. It was apparently an error, and that Mr. Beglin's note was, to quote the email from the council on Friday, finalized at a point when we were looking at the potential for a statement of common ground. So the program officer has been copied on that email by the council if you wish to see that. What is notable is that WBC doesn't say in that email there isn't a statement of common ground. It says they haven't submitted one, and perhaps when they turned to it, it turned out to be unhelpful. Whatever the answer to that mystery, the fact does remain that the owner and the developer of the site are completely absent from the discussion. Mr. Beglin's note doesn't even refer to any discussion WBC had with either of them. And until 5 minutes ago, really, there was no evidence of either of them having had any legal advice that offers any prospect of success of an application to discharge or modify the covenant, still less a reasonable prospect. And noticeably, sir, we'll perhaps come on to this, but when you read Mr. Beglin's note, he doesn't even offer his legal opinion, and nor do I think we heard it in the last 15 minutes, that there are reasonable prospects of such an application succeeding. And we suggests, sir, that there is a reason that none of WBC, Stretton Milford, or Carla has put any legal advice before you saying there is a reasonable prospect of an application to discharge or modify the covenant succeeding. And the reason for that, I think, can be found in Emily Windsor's opinion. For the reasons that she gives, it has consistently been our view and consistently been the view of our legal counsel that there is a very high probability that any such application will fail. Now, we haven't made a secret of that, and we haven't made a secret of our advice. Our advice has been in there in writing on both before Inspector Bohr and now, of course, before you, sir. So what I wanted to do with those preliminary points out of the way then is go to the specific points on Mr. Bigland's note. And I'm going to do it, if you have it in front of you, paragraph by paragraph, but I will try to be quite brief because the more important submissions will be from Emily Windsor in a minute. But paragraph 1, just to note, that's where the reference is to the joint statement to update the factual position, which hasn't appeared. Paragraph 2 makes this point about Inspector Bohr having considered the points. Inspector Bohr's decision was based on the information that he was given in 2017. As noted in the opinion, the law has changed, which is one thing that's changed since then. But I also laid out, and I won't go back to it, in paragraph 2.7 of the original hearing statement, all the other factors which have moved on since 2017, 2018, when Inspector Bohr came to his decision. And we can now add to those factors the new facts that the council, for the first time, are accepting the enforceability of the covenant. You will have seen Mr. Begland's previous notes, which he's referred to, where he cast doubt over that and made various, I would say, slightly prejudicial observations about whether or not we had disclosed documents from conveyancing files, all directed to the suggestion, well, it's unenforceable. Well, Shoesmith some time ago, more than 2 years ago, accepted to us that it was enforceable, and the council have now just done the same. And secondly, disavowing any intention to use the section 203 powers. You'll have noted previously, and it's still sort of held there as a shadowing thread. But before you, sir, there is a disavowment of any intention to use the section 203 powers, and I would say appropriately so. Paragraph 3 of Mr. Begland's note makes a point about the application for judicial review. Well, the fact that an application for judicial review of Inspector Bohr's decision failed and that we chose not to appeal is not relevant to the entirely different question with which I think this examination should be focused, which is whether or not the owners of the Milford Golf Course site will succeed or have a reasonable prospect of succeeding in modifying the covenant. We, of course, say that they don't. Paragraphs 2 and 3 of the note, in any event, they all hark back to Inspector Bohr's view. In any event, Inspector Bohr's view in 2018 has been comprehensively rejected by all of the Section 78 inspectors that have been mentioned by us and by others in previous submissions. And I do note that Mr. Begland has made no reference to that, preferring, I think, to wind the clock back to 2017. Paragraph 4, I don't understand of Mr. Begland. There's been no challenge to the grant of outline planning permission or the decision to approve the reserve matters. Mr. Begland's aware, and indeed has just made the point, that private law rights are not a basis for appealing planning permission decisions. So it's really not clear to me what point Mr. Begland is trying to make about the covenants in paragraph 4 of his note. Paragraph 5, the council considers that MGC remains developable in the circumstances and talks about the relevant test, and this is what's been addressed. there is no reasoning whatsoever to explain why the council considers that the MGC site remains developable. To be of that view, the council must surely hold a reasoned belief that the covenant can be discharged. Now, if it held such a belief, and if it could evidence that that belief was based on some informed legal opinion, well, then the site would be not just developable, but of course it would be deliverable on a 5-year horizon. And it would therefore be worthy of inclusion in the 5-year housing land supply statement. But that isn't the council's position. The council concedes, it seems, that the site can't be delivered in 5 years because of the covenant. Well, that I think raises the question, what is it that the council believes will change between the current position on a 5-year horizon and the end of the plan period in 2032? You know, and I could be flippant for a moment, and perhaps they, you know, do they think that we will mellow with old age, sell the property, or die in the meantime, and therefore a more compliant neighbouring owner will capitulate where we have resisted? Paragraph 7. Mr. Beglin's note here tries to keep alive, I suggest, the prospect that, you know, we will capitulate and we will negotiate when we see this much talked about, but currently a phantom Section 84 application, which we have made clear we won't. And Mr. Longland's own reference a second ago to shoesmiths being willing to have a dialogue is, it's a controversial statement, actually, so it happens, but we have given our own unchallenged evidence that we will resist this application and that we will not be bought off. Mr. Beglin and others suggested otherwise in 2017. We're 5 years on now, and there is the same slight insinuation here that, you know, that things will change and we will capitulate and we'll be bought off on this. I have made the position, I think, crystal clear on that, and I would appreciate it if these insinuations stopped. Paragraph 8. This is the paragraph where, paragraph 7. Just to go back to paragraph 7 for a second on negotiation. Mr. Beglin's note doesn't address why no Section 84 application has yet been made. And this is something that a statement of common ground or even a letter from the owner might easily have addressed, but there is neither. And if there were such an application in the works, and if it were likely to be so compelling that it would change our point of view in some way, then one would have expected that application, I think, to have been made hot on the heels of obtaining full planning permission. But having obtained full planning permission in mid-November, we then permitted leading counsel and the valuation expert in early February for Stretton Milford to come to our house, to walk around the property, to take photographs of every room and from every room in our house. And this was on, I think the 8th of February, which is not something we're required to do or something that is any kind of obligation on us to do prior to any application. But we did that for a purpose. And the purpose was, if there is going to be an application, let's have it and let's deal with it. And let's not stand in the way of this application. Let's make it straightforward. And frankly, there was a further purpose for that, which is, you know, if we are right in our consistently held view that we have a strong case to resist a Section 84 application, let's have Stretton Milford's QC come and have a look at it, walk around the property, have his expert with him, take whatever photos they want to do, and let's get on with the application. Because it's not in our interest any more than it's in anybody else's interest to have this uncertainty hanging over the site or our property. Since then, absolute radio silence. And since then, absolute radio silence, despite the fact that we have, I think, in some ways provocatively been saying in these proceedings, Where's the opinion? Bring it on. Here's our advice. Here's our opinion. Here's our expert evidence that sustains that opinion. And yet we're still a number of months away from that. And all that you've heard is 5 minutes ago, a statement from one of the planning officers to say, oh, we've been on the phone to Shoesmiths and they're happy to tell us that it's all in the process and we've got great legal advice. I think that's completely unsatisfactory. Paragraph 8 of Mr. Beglin's note is the paragraph where he conspicuously does not express an opinion on the merits of a Section 84 application. What he says there is, as to modification, ultimately this is a decision for the upper tribunal. However, in the council's view, there are a number of features in this case which militate strongly in favour of an appropriate application being made in the light of the clear public interest. These have largely been set out before. I won't go into them again. The council continues to consider the public interest case is compelling. Where is the opinion from any lawyer on behalf of Stretton Milford, Carla, or WBC that a Section 84 application will succeed or even stands a reasonable prospect of succeeding? And the evidential position in front of you is there is none. And I think that that is starkly in contrast to the open and transparent way that we've dealt with our advice throughout. And you know, to be frank, we'd invite you to consider why that is the case. All of the other points in paragraph 8, I'm going to leave because they're specialist legal points in relation to the law relating to covenants. I'm going to leave Emily Windsor to deal with those, if I may. And also in paragraph 9, this is really council's domain, except to note again that at least when this was prepared and signed off on the 19th of August, there was apparently, see paragraph 9.c, a statement of common ground, which was laying out the factual matters. But this paragraph, I think, also lays out quite starkly, to my mind, the illogicality of excluding the MGC site from the 5-year housing land supply, but including it in the longer term plan on some unexplained basis that it is to be developable notwithstanding the covenant. And then the last point in relation to this is paragraph 11. The existence of the covenant doesn't render unsound the councils. Well, we do disagree, as you know, so with that conclusion, and for all the reasons we've previously given, and now additionally supported by Emily Windsor's written opinion. There is no evidence before you that there is a reasonable prospect of the covenant being discharged now within 5 years, or even by 2032. On the contrary, the evidential position is that there is strong evidence before you that it will not be. So sorry, that took a little longer than I was perhaps anticipating, but I wonder whether either I could deal with any of your questions on that, or perhaps hand over to Emily Windsor.
Thank you, Mr. House. Yes, if we could hand over to Ms. Windsor, please.
Thank you very much, sir.
Good morning. Can you hear me?
Yes.
Thank you. I should say, first of all, that I have a small IT issue in that this morning I am unable to open Mr. Beglam's latest note, and I wonder if someone would please be able to email that to me.
I can do that.
Thank you very much. Do you have my email address? You may not. It's
No, I do. I do.
Oh, you do? That's very kind of you. Thank you very much.
That's fine. I'm the program officer. I sent you the invite. So.
Oh, thank you very much. Right. Well, I'll continue while that comes through. Essentially, my role today is of a property law specialist. I'm not a planning specialist. My role is property law, and I should say I have. Now my screen has gone black, but is everybody else still there?
Yes. Can
you
hear
good. Good. I'm a property specialist. I have a particular expertise in restrictive covenants, and I was engaged on behalf of the objectors in the most recent Supreme Court case concerning Section 84 of the Law of Property Act, which was in fact the only case that has ever reached the Supreme Court. For the last 4 years or so, this has been very much my area of expertise, although I freely admit that planning is not my area of expertise. I'm a barrister, I'm self-employed, and accordingly, the views I give in my written opinions are those that I have to genuinely hold independently. And I would not have signed the opinion I did if I did not believe what I had written. And those opinions are based, as I say, on my expertise in the area and my experience in the area. As I understand it, my role today is to address the likelihood of the restrictive covenants affecting Milford Golf Course being modified or released. And that's in the context of the planning law test of developability. I've read Mr. Beglam's latest note, and obviously I listened to what he had to say this morning. My view as a property practitioner remains that the prospects of this application to procure this scheme of 190 homes is unlikely to succeed. Now, I put a percentage on it of 30% chance of success or a 70% chance of failure, whichever way you look at it. I stand by that. Obviously, it's not a scientific exercise. It's a matter of opinion and judgment. And the number is really just a guide. But my view and my submission is that the prospects of success are small, and that is why I quantified them at 30%. I have not seen any legal opinion from an equivalent property practitioner acting for the developers, although I did note with interest what was said this morning, I think to the effect that the developers claim to have good grounds, but accept that the outcome is uncertain, and repeat that they are trying to seek a negotiated compromise. So it may well be actually that once any written opinion were produced by the other side, we would really not be so far apart, the property practitioners, because I discern in that summary that was given, which we've never seen in writing, some considerable doubt on their side. There is no obligation on Mr. and Mrs. House to negotiate at all, and they've indicated their clear wish to have the covenants upheld. So the issue is whether, as a matter of law, this application will succeed before the tribunal. The relevant covenant, as you will be aware, was imposed in 1929, so that's some time ago. And essentially, it's a density restriction on development. The restriction is 1 dwelling house per acre with ancillary staff accommodation. Whereas, of course, the scheme that's being presented is very different and very much more dense. A restrictive covenant is a property right in which binds successors in title in much the same way that a right of way is. And I think it's important to recognise that that is the starting point for any application before the upper tribunal. The starting point and the considerations are very different than they would be in the planning sphere. It is a property right, it's a registered property right. So if you buy a property with the benefit of a restrictive covenant, that makes it more valuable. If you buy a property burdened by a restrictive covenant, that makes it less valuable. And it's important to bear in mind that at all times, this site has been burdened by a registered restrictive covenant. That will affect the price that's been paid for it over the years. Everybody involved will have known that fact. And so to some extent, all of these developers are seeking to take away established registered property rights. And that will be the starting point for the upper tribunal. Now, I'm aware that planning permission has now been granted, and that this site is included in the current local plan as a strategic site. But the issue in planning terms is whether the application, the Section 84 application, will succeed before the upper tribunal. Now, previously, it's been suggested in correspondence by shoesmiths that they might run at least 2 of the 4 available grounds. In reality, there's only one ground that has any prospect of success, as I explained in my opinion, and therefore I don't propose to cover the other grounds, as I regard grounds A to C as wholly unrealistic, and I don't think any barrister acting for the developers would suggest otherwise. Those grounds are that the restriction is obsolete. Well, it's plainly not. It clearly does something. That the parties have agreed to the covenant being discharged. Well, they clearly haven't. Or the tribunal is satisfied that the modification will cause no injury to Mr. and Mrs. House. Well, no one reasonable could say that. So despite what's said in correspondence from the developer, grounds A to C are dead in the water. The only ground that has any prospect of success is ground AA, which I set out in my opinion. But essentially, there are 2 limbs to this. It's essentially 2 tests in one, and the developer has to satisfy one or the other. The first limb is that the restriction does not secure benefits of practical, of substantial value or advantage. So in other words, the developer would have to demonstrate that this covenant in restricting the number of houses to 27 plus staff accommodation did not confer any benefits on the house family as opposed to the 190 house development. And I don't think, well, my submission is that the tribunal will not be troubled by that test for particularly long, because in my submission, in my opinion, it's very clear that there is a world of difference between the development that is permitted by this covenant and the development that is proposed. We are comparing 27 houses with staff accommodation, with 190 houses and all the corresponding gardens and driveways and garages and the like. So the question for the tribunal is, does that covenant confer a substantial value or benefit to Mr. and Mrs. House? And the answer is plainly yes, it does. So the prospects of the developer succeeding on that limb of ground A are very small indeed. And I haven't seen anything to suggest that they are seriously suggesting otherwise. Clearly, this benefit, this covenant confers a significant benefit to Mr. and Mrs. House. The only real battleground is this, the alternative limb, the public interest limb. And it's important to bear in mind, a lot has been said about public interest and my views on that, but it's important to bear in mind what the test is, which is whether the covenant is operating contrary to the public interest. That's the test. Is the restrictive covenant operating contrary to the public interest? Not is the housing in the public interest, but is the covenant operating contrary to the public interest? And there is quite a difference between, it may sound like semantics, but there is quite a difference between those 2 positions. There are 8 or 10 cases, some of which I have cited in my opinion, and some of which I have not, in which the courts and the tribunal have considered the application of this test. And essentially what the tribunal has said repeatedly, and I've cited some of those authorities, but there are 8 or 10 of them, is that there is a difference between asking whether a development is in the public interest and whether the restriction is operating contrary to the public interest. And that it's important to focus on the right, to view this test from the right perspective. And I set those out in my opinion at paragraphs 34 and 35. And in particular, the tribunal has acknowledged repeatedly that there is plainly a housing shortage in this country, and that there has been for many, many decades. and that no one would deny that it is desirable for more houses to be constructed somewhere. But in order for an application under the second limb of AA to apply, the tribunal has to date asked itself whether the particular project could be built on other land. And if it can be, then the application under this second limb of ground AA fails. And that's because although providing additional housing may be in the public interest, there is still this issue that there are binding private covenants affecting the particular plot. I heard Mr. Beglan earlier refer to my summary of O'Reilly's application. I don't accept his criticisms of that. I can prepare a note in writing if that would assist, because obviously the first I heard of what he would say about that was today. But my submission is that my summary at paragraph 39 of my opinion is accurate, as can be seen from a reading of that case, and it's one of many cases to the same effect. That is, to date, the tribunal has required evidence that there are no alternative premises at which the public interest could be met before it will allow an application under this limb. So one of the key questions, and this is always a key question for the upper tribunal, is could this housing be built elsewhere? And my understanding on land which is not burdened by a restrictive covenant, and my understanding is that there are a number of other sites that were under consideration and that could still be incorporated in a local plan. And as far as the upper tribunal is concerned, that is highly relevant evidence when deciding whether the covenant affecting this golf course is operating contrary to the public interest. Because if the same housing provision can be delivered on other land, then there is no reason to interfere with private law covenants. And the public interest is not affected by the land being, by the development being built elsewhere.
Can I just come in there, sorry. So in terms of the tribunal's assessment in that respect, they're looking at alternative sites or alternative premises. To what extent would they then sort of go under the bonnet, if you like, and see if there were planning permissions elsewhere that meet that need? Or is it a theoretical? Yes, there's some other sites.
It's theoretical. So, because essentially it's the developer making the application, the burden is on them to satisfy the tribunal that private property rights should be taken away. Now, this is a developer that has purchased land in full knowledge of the existence of the covenant, and they are now invoking a Section 84 jurisdiction to persuade the tribunal that these property rights should be forcibly removed. And in order to do that, and applications under the second limb of AA are relatively rare, in order to do that, they need to, according to the tribunal and the established line of authority, which I refer to in my opinion, they need to, the tribunal will ask itself whether the housing could be built elsewhere, because the test for the tribunal is whether the covenant is operating contrary to the public interest. And if the housing can be built elsewhere, then it's not. And if there, so essentially what I say that the developer would need to establish is that it is not, there is no other land on which this housing development could be built, or an equivalent number of houses could be built. And it doesn't need to be an identical site, it could be two sites. And that is the difficulty these developers have created for themselves by applying for permission and promoting a site in respect of which they know, as a matter of property law at the moment, the development cannot be delivered. And ultimately, it's presumably the reason this development has been pursued on this site is either for financial reasons, because the price paid for the site reflected the presence of the covenant, or because there was some assumption that Mr. and Mrs. House could be swept aside. But everything that has been done in the full knowledge of the presence of this covenant and the fact that it prevents this development. And ultimately, if the application is made to the tribunal, they will have to satisfy the tribunal on the present state of the authorities that this housing can't be built elsewhere in the area, in the local area. Now, it may well be, and I fully accept, that the tribunal may depart from the last 20 years of authority, and it may decide that this is the time to change the law, although, of course, were that to be the case, there would presumably be a number of appeals. But as the law currently stands, the prospects of this application succeeding are small. Quite how you quantify that it is a matter of judgment, and lawyers may agree or disagree on the precise figure. But the fact is that the test is clear, and it's as I've set out. That the question is whether the covenant is operating contrary to the public interest. And I fully accept that as part of that, and Section 84 mandates this, the tribunal will have to consider the planning position, the local plan, all relevant factors. But ultimately, the test it then applies, having considered those factors, is whether the covenant is operating contrary to the public interest. And to date, this approach it has always taken, admittedly on some cases which are very different from the current facts and some which are nearer the current facts, is that if the development can be built elsewhere, then the covenant is not operating contrary to the public interest. And that is the way the law of restrictive covenants works. Now, I'm just turning to Mr. Beglin's note. And I'm very grateful to Miss Glancy for sending it. Much of what Mr. Beglin, before I turn to that, would it assist if on O'Reilly's application, that the points Mr. Beglin made, would it assist if I submitted a further note on that?
I'm minded, Ms. Windsor, to ask for the authorities to be uploaded onto the examination website, so the cases that you've referenced, and then take a view following this hearing whether I need any additional material on that. But I'd cover that in post-hearings correspondence. So for the time being, if I could just ask Mr. Beglin to make a note of that, yes, I think it'd be useful to have the material that we've discussed thus far. But as I say, I'll reflect on whether I need any additional notes after the hearing's closed.
So yes, noted. Thank you.
Thank you. Yeah, please continue, Ms. Windsor.
Mr. Beglin has, at paragraph 8 of his note, identified a number of factors which he describes as compelling. I accept that they are relevant, as all factors are relevant under Section 84, that the site has been allocated as a strategic site, that the development will provide a substantial number of new homes. However, I differ with him on his analysis as to the likelihood of the application succeeding for the reasons I've given. Essentially, the grant of planning permission, the presence of the development in the strategic plan are only two relevant factors that the tribunal needs to consider when considering whether this private law right is operating contrary to the public interest. And another highly relevant consideration, as I've already indicated, is whether housing could be built elsewhere in the area, which is not a point that has been addressed on the evidence I've seen, save that I'm aware there are a number of potential alternative sites. There are a number of factors that Mr. Beglin identifies which are not relevant. The age of the covenant is irrelevant. The fact it was imposed in 1929 it is neither here nor there if it still serves a purpose, which this one clearly does. Mr. Beglin also comments that the covenant permits significant development on the land. Well, that's true, but as I've identified, it's a very different type of development anticipated by the covenant. It's up to 27 1-acre plots. And of course, some of the land, as I understand it, is too damp to be built on. So it may be that it would not even be possible to build 27 houses plus ancillary staff accommodation. That is very, very different from what is proposed, as I think we would all acknowledge. The rest of Mr. Beglin's note proceeds on a number of assumptions which are inconsistent with the property law position. I don't want to repeat myself, but essentially what I'm saying is that viewed through a property prism, the test is relatively clear, and the answer is in my submission unlikely on the current evidence to go in favour of the developer, which is not to say that it will fail. I think it would be unwise of any lawyer to submit that it will fail. But the application is, in my submission, an uphill battle with small prospects of success. And to some extent, that may be evidenced by the lack of action on this front. Counsel for the developers last viewed Mr. and Mrs. House's property in February. Since then, absolutely nothing has happened. There has been no application. And if it were really as straightforward as is being suggested to procure this modification, one wonders why nothing has happened and why there is still talk at every opportunity of the hope of Mr. and Mrs. House giving in and negotiations being successful. And that may be the best evidence of all of the difficulties the developer faces, the fact that this application, despite talk now for over 3 years, I think the letter for action was 3 years ago, has not happened. And I say that's for good reason. So I'm very, if you have any questions, sir, that I can answer, I'm very happy to answer if I can.
Okay, so in terms of just in terms of Mr. Beglin's point and your point in your opinion, Ms. Windsor, on planning permissions being a close run thing, and it was that the Lamble and Batachi case.
That's the preliminary test. I dealt with the two main limbs of ground AA. There are further matters that the developer would have to establish to succeed in this application. I addressed you on the two main limbs because, in my view, one is entirely hopeless and the other is an uphill battle. However, taking the matter through logically, or the application through logically, the position is as set out in my opinion. The first question is whether the proposed user is reasonable. As I said, ordinarily, the grant of planning permission is taken to be evidence that the proposed user is reasonable. If a planning authority has looked at something and concluded that permission should be granted, that's taken as reasonable user. However, there are cases, Lamble and Butacci is just one example. There are at least 3 or 4 cases in which the tribunal has been at least prepared to look behind the grant of planning permission and look at the circumstances of the grant. So essentially, it's a starting presumption that if planning permission has been granted, the user is reasonable. But it's open to an objector to say, to invite the tribunal to look behind the grant of the planning permission, to look at the circumstances of it. And here, for example, Mr. and Mrs. House could take the point that in the early days, misrepresentations were made about the enforceability of this covenant. And therefore, for some time, the planning application proceeded on a different premise. Mr. and Mrs. House can also point to the degree of opposition that there was to this planning application, not just from objectors, but also, as I understand it, from either I think it was the district council or the borough council and some of the planning officers. But certainly it wasn't an open and shut application. And so Mr. and Mrs. House can point to that fact, that there were a number of voices from all quarters against this application as well as for it. And they can invite the tribunal, therefore, to form the conclusion that although permission was granted, this user is not reasonable, based primarily on what the dissenting voices said. Now, the tribunal may not accept that submission. I don't want to state the position too highly. That is an argument where there are good arguments to be made both ways, and it's fact dependent. But I think for the purposes of this inquiry, suffice it to say that it is open to Mr. and Mrs. House to challenge whether the proposed user is reasonable, and they may succeed. I don't want to put it too high, but it's not fanciful either. It's the sort of legal argument that after argument could be decided either way. The reason I focused on the two limbs was because essentially, whether or not Mr. and Mrs. House succeed on that, essentially I don't see them establishing either of the two main limbs. So to some extent, I think that's where the battle is going to be. There's also a further question I identify, in my opinion, that even if one of those two limbs can be made out, and it's far more likely to be the public interest limb than the substantial advantage limb, but even if the public interest limb can be made out, there is a final consideration as to whether money would be adequate compensation. And there are real arguments around that as well, as I set out in my opinion towards the end of page 8, that essentially even if both of the limbs are satisfied, the tribunal must be further satisfied that money would be adequate compensation to Mr. and Mrs. House for the loss of the benefit of their covenant. Now, the tribunal will inspect the property as part of this inquiry. That's standard, and they will hold the plans in their hands. They will stand in Mr. and Mrs. House's garden and in their house, and they will ask themselves whether money will be an adequate compensation for the presence of 190 houses, 190 house development, as opposed to a 27 house development. And they may well conclude, and their lawyers will certainly be submitting, that the answer is no, that money would not compensate for that. And in that case, even if the two limbs are made out, the application will fail. But for the purposes of, and again, as in with the previous question we were discussing, whether the user was reasonable, there are arguments both ways. I represent Mr. and Mrs. House. I would say that their position is strong on that. But again, that all depends on the tribunal assessment based on the facts and the expert evidence. The reason I focused on the two main limbs is that in my submission, that is going to be the sticking point that the developer will be unable to get past, or either of those limbs, and their prospects of doing so are very small.
Okay, thank you, Ms. Windsor. Mr. Mools, you've had your hand up for a while. If we'll bring you in, please.
Thank you, sir. Just a couple of brief points to follow on from that. The starting point is the council now accepts the covenant won't be removed through negotiations. You've heard that it has no current intention to use section 203 and that further decisions would be required in order to go down that route. So it is relying on modification under section 84. The key test then is the public interest test. I endorse what Ms. Windsor has said. The correct question for the tribunal on an application under section 84 is the covenant contrary to the public interest? And in answering that question, the availability of alternative site or sites is highly pertinent. I also agree with what Mr. Beglan said, that these applications are very fact specific. And what I want to do is just point to some of the facts in this case, the planning facts, that will be highly pertinent to the merits. Here, we have a development plan, part 1, which contains a number of asterisk sites in and around the settlement in question as potentially suitable for greenbelt release to accommodate housing. We've heard already the Reg 18 and the sustainability appraisal looked at those and found no showstoppers and found they were suitable for housing and sustainability terms. Ms Ashton has, in her Appendix 1 to the hearing statement for these hearings, presented the total number of units, both looking at the Reg 18 sites and the other asterisk sites. So that's Appendix 1 to her contingency hearing statement. And it's obvious from that table that there are other sites in this settlement that could accommodate the quantum of housing allocated at Milford Golf Club. So that the council's own evidence base and the terms of its own adopted development plan would provide powerful evidence that the alternatives test would not be satisfied. Second point I wanted to pick up was a lot of emphasis has been placed on what Inspector Bohr said. I'll invite you to read paragraph 122 of his examination report. Really the last sentence where he reaches the conclusion, however, the need for housing land to be made available in the public interest and the strategic exceptional circumstances for greenbelt release point to a reasonable prospect of the covenant being varied, modified or discharged under section 84 to enable the full capacity of the site to be achieved. So 2 points there. Firstly, it's not clear he's actually asked himself the correct question. He's not asked himself, is the covenant contrary to the public interest? He's simply referred to the general public interest in housing land being made available and the strategic exceptional circumstances for greenbelt release. And in any event, all of those points apply to the asterisk sites and the Reg 18 sites. They would provide the required housing in the public interest. And they are sites that the Part 1 plan identified as being suitable potentially for greenbelt release. So in my submission, nothing Inspector Bohr said is remotely an answer to what would happen on a Section 84 application in the tribunal. And then thirdly, what all of this underlines, whether you're with the council or not, is the fragility of their supply. And these are points we made back in July. I won't repeat them, but even if you are with the council, it underscores the fragility of the supply and the need for additional allocations to ensure that the minimum housing requirement is met. If at that point, so I could bring in Ms Ashton perhaps to make the point about the trajectory that you referred to earlier.
Yes, please. In terms of the, it was your point, Ms Ashton, on the planning permissions and when they might need to be implemented. If you could just run those past me, please, for the benefit of the hearing.
Thank you, sir. Yeah, paragraph 1.4 of my statement for the focus questions just deals with the point about the timing of the consents for Milford Golf Course. As I've set out in the outline, consent was granted in February 2019 and the reserve matters was issued in February 2021. The actual timings are such that if the developer is to implement the outline consent within the timescales set out within the outline, they have to do so by November 2023. Now, the council today have suggested within their trajectory that they are looking at Milford Golf Course delivering from 2027-28 onwards. Clearly, that is beyond the date of the outline consent. And I would suggest, sir, that for a developer to start to implement a consent to demonstrate it has been implemented with intent and then walk away for 5 years before they can do anything is just basically, well, it's something I would never know any other house builder to do. They won't do it. In the current economic climate, they would want to start, complete and get out. They're not going to want to start, stop and then come back in 5 years' time. And I don't understand the rationale behind the local authority's position on this. It is totally and utterly incredible, to be quite honest. And I would suggest that, given the current situation, Milford Golf Course should be totally and utterly removed from the trajectory. And as set out in my Appendix 1, alternatives should be provided for, as can be demonstrated within the local area. And as Mr. Moores has said, went through Regulation 18 within the SA as suitable alternatives. And they, together with other sites, would actually provide for the 480 that the local plan part 1 suggested could be provided within Milford, and possibly with an additional buffer to address this issue of fragility that we've raised on a number of occasions now. Thank you.
Thank you, Ms Ashton. So I intend to take an adjournment now until 12:05, and then I'll come back to the council for responses in the round to those points and some additional questions that I have on this specific topic. So if we could adjourn now, thank you. Okay, if we could resume the discussion there. So as I flagged before we adjourned, that I intend to go to the council now for their responses to that. But in your responses, Mr. Beglan, I'd be interested to hear. So if I were to take the view that I'm being invited to take in terms of the golf club site, that it's not developable in the plan period, what if anything would the local plan part 2 have to do about that, particularly in terms of the requirements for Whitley, including Milford? And also what would be the role of the review of the part 1 plan and potential monitoring review of the part 2 plan as well? So just taking those things together with your responses to the other points we've heard, Mr. Begler, would be useful for me.
So thank you. I'll pick up on those points as we go through. So before you just ask those questions, really 7 short points from me by way of response. And I make these responses on the basis that you've indicated that your contempt for the authorities that Ms. Windsor has referred to be added to the examination library. So you can read them for yourself and see the extent to which they support either our position or Ms. Windsor's position, or indeed are so factually distinct from the situation that's before you that they perhaps provide very limited assistance on the statutory questions that arise for the upper tribunal. So on that basis, first of all, in relation to the views that the council has put forward in the 3 notes, so you will have noticed that the 2nd and 3rd notes, as well as being the position of the council signed by me and put forward to the, first of all, to Inspector Bohr and then, sir, to you on that basis. Secondly, in relation to Mr. House's point about, well, what's going to be different between the position now and in perhaps a couple of years' time? But why isn't the council saying that this site is deliverable, rather putting it down as a site that is developable? Well, the answer to that is the acknowledgement that the application to the tribunal is in all likelihood going to be required, and that will lead to a level of delay. Unfortunately, and so the council in that respect is being, we would suggest, sufficiently conservative and acting in a proportionate way in where it has put the site into the overall trajectory. Third, in relation to experience of covenants and things like that, it's not appropriate for any of the lawyers around the table to get into a spat in front of you in terms of experience in various matters, but you will of course know that planners are routinely called upon to consider and look at covenants, including restrictive covenants, things that arise in Section 106 agreements, and so on. The 4th point, you asked Miss Windsor about whether or not, when alternative sites are being considered, there's any ability to look over the bonnet, or whether it's an entirely theoretical exercise. I will invite you to look at the authorities that are going to be provided to see if there is an example of the tribunal approaching it on a completely theoretical basis. We suggest that that's not how you assess public interest. You assess public interest by looking through a realistic lens as to what the alternatives potentially are. And in this case, the land that we're concerned with does have the obvious advantages that Inspector Bohr has already set out, and its allocation as a strategic allocation within Part 1. All of those things we say the tribunal will ultimately consider, and in relation to the tribunal's ability to consider those features, at least, I didn't understand there to be a dispute between the council's position and Ms. Windsor. A couple of points in relation to Inspector Bohr's report. It's there, you've considered it, you will see that when you look at his reasonings for the conclusion he gave on the covenant issue, which were as far as he needed to go and as far as you need to go in dealing with local plan part 2, he gave his reasons, and the relative enforceability or not of the covenant was no part of those reasons. So that wasn't an issue that he thought was important in resolving it. He set out the factors that he considered were important. And so in that respect, it's important to bear in mind that in the absence of any successful legal challenges, it's really not open to the participants now to say that Inspector Bore misdirected himself in some important way in considering this issue. He had material from both sides in front of him. He had references to the statutory provisions in front of him, and he came to a clear conclusion on the point. The other issue that's raised by Miss Windsor, albeit as perhaps a secondary issue, but towards the end of her advice, is the issue about compensation. And so again, because you're going to look at the cases that have been referred to, I will just invite you, when you look at those cases, to also consider the way that the tribunal approached issues, or the courts approached issues of compensation in those cases as well. And you'll see a variety of mechanisms were used. Now, in relation to the question that you've asked us most recently, we say at a high level position in relation to part 1 and part 2, for reasons that we articulated last time round, and I won't rehearse for the purposes of today, that in relation to part 2 being the daughter document that it is, there's no obligation in relation to the 5-year housing land supply. And even if you were to find that there is such an obligation in guidance, then it remains open to you, for the various reasons we articulated on previous occasions, to depart from that in certain specific respects. And one of the reasons for that is that not only was the amount of housing that was set out by LPP1 important to its success, but the distribution that we referred to at the last set of hearings as being very carefully calibrated between the 4 main settlements and the other villages was also set out by that document. So there is that important relationship there that we say sound spatial planning requires to be preserved. And then in relation to the review, of course, the review will consider whether there is a need for further housing sites, in particular, further strategic housing sites. So again, to the extent that an issue like Dunsfold, something of the size of that, or the other strategic sites, comes up for reconsideration, if LPP2 is to genuinely be preserved and to be found sound as a daughter document of LPP1, then it has to respect those issues that we dealt with at far greater length on the last occasions, and so I don't rehearse them now. But having said that, on your last question, I will then turn to the team, perhaps to Mr. Ellis, or the other members of the team, to see if they want to provide further information on that question.
Yeah, so on that specific point, clearly it's one of the strategic sites in the Part 1 local plan, and we've suggested to you that if you're of a view that those sites can't come forward, and this is obviously not the only one that we've talked about during the course of the hearings, we see that being a matter for the Part 1 local plan to resolve. But clearly that's a matter for you to decide and to advise us what you think we need to do to make a sound plan. If I could just touch on the points, I think you wanted us to respond to the points that Ms. Ashton has made regarding the implementation of the planning permission. Yes, I don't disagree with her analysis around the timescales as set out in the planning conditions attached to the consent. Obviously, there's no impediment to an applicant reapplying for permission should they fail to meet those timescales. And as it is a strategic allocation in the development plan, and as it would have a supportive planning history, I see no reason why the council wouldn't wish to grant consent again. And I only raised this because Ms. Ashton raised it in relation to commencement. Obviously, it's not uncommon for developers to commence their developments in order to keep a planning permission alive, and that would be a matter for the promoters of this scheme to take a view on whether that was an effective way to keep their planning permission running, or whether they wanted to apply afresh. But that would be a commercial matter for them, and one for the planning lawyers, I suspect.
Okay, thank you, Mr. Longley. Any responses to the suggestions of Mr. Mills and Ms. Ashton in terms of potential solutions that were, for alternative sites in Milford and Whitley?
Well, so we've obviously given our views on those sites at some length in previous sessions. I think the only point I would make is that, and it is a matter of fact, the council has done a lot of work and analysis in relation to those asterisk sites previously, and that is a matter of fact, and they have been in the public arena. So, insofar as we're not starting with a blank sheet of paper, I'd put it that way.
Okay, thank you. So, final point specifically on the Milford and Whitley position and the golf club in particular. So I'll go to Mr. Neame first, please.
Thank you, sir. Well, just 2 points, if I may, sir. And you'll correct me if I'm wrong on this, but first thing this morning, I think you asked one question actually twice to the council, both to Mr. Beglin and Mr. Longley, regarding their view on the timescale for dealing with the covenant process relative to the RM approval for Milford Golf Course. And again, you'll correct me if I'm wrong, but I don't think either party gave you an answer to that question. So, which is interesting because particularly in the light of Mr. Longley's most recent comments just now, that it's not uncommon for a developer to commence development to keep it alive. And as you will have heard from Ms. Ashton, that is highly unlikely to occur. It's interesting for that reason, but it's also interesting for the reason, so that the council's own evidence actually gives you a view from Carla. And so that evidence-based document is the 5-year housing land supply statement, which is CD 228. And if we look at the appendices to that, sir, specifically Appendix 4, sadly the document isn't paginated, but it is the very last page of Appendix 4, paragraph 1.28. So if I may, I'll just read. It's a very short paragraph, but just for the benefit of those other parties on the call. It says that there is a restrictive covenant which affects the site being Milford Golf Course. For the site to be developed, the covenant will need to be overcome prior to any development taking place on the site. Carla Homes have confirmed that they are aware of the covenant and that they plan to address it before development commences on site, specifically before development commences on site. Correspondence with Carla Homes confirms that they've set aside 18 months in their build programme to address the covenant. So, sir, you have the council's evidence there, which is directly from the developer who we've heard has a contractual position on the site. Clearly, sir, the mathematics don't add up, because if they've allowed 18 months and they haven't started the process, and we already know that the permission expires in November next year, that it is effectively not possible for that permission to remain extant on the basis of what is an entirely reasonable approach for Carla to take, as Miss Ashton has already confirmed. So that's the first point, sir. The second point is really quick because I am not going to go back over old ground, but it relates to the response you've just had from Mr. Longley regarding the what if Milford Golf Course is not developable, how do we deal with it? And specifically that he says that it's not a matter for the Part 2 plan, that it's a matter for the review of the Part 1 plan. And so I'll just refer you to my previous comments on that in relation to both the Council's own local development scheme, referring to the Part 2 plan meeting housing needs, not specifically meeting housing needs on specific sites and in specific settlements. And then, of course, to the points that I'd made in relation to the supporting text to policy ALH1 of the local plan Part 1. I'm not proposing to go back over that, sir, because I know that you've got a very good note on that. Those were just the 2 points I wanted to make.
Thank you, Mr. Neame. Ms. Windsor?
I wonder if I could please just make 2 brief points. The first is in relation to timescales and whether it's open to the developer to keep the application alive, to quote, meanwhile. On the question of digging a few trenches to keep the application alive, as a matter of property law, the courts have made abundantly clear that they take a very dim view of developers trying to, quote, steal a march by doing that. Essentially, as a matter of property law, it would be unlawful for the developer to dig a single trench at the moment because the covenant prevents them doing that. And it would be an immediate breach of the law that would be injunctable by High Court proceedings. So as a matter of property law, there is no question, or there should be no question, of the developer digging even one trench. And were it to attempt to do so, Mr. and Mrs. House could go straight to the High Court and the High Court would take a very dim view of it. The correct approach, as the courts have made abundantly clear, is for the developer to pursue the Section 884 route. It's there for a reason. And until such time as the covenants are relaxed or modified, a developer cannot assume that that is going to happen. And any developer that does so will be wrapped over the knuckles. So from a property law perspective, it is wholly unrealistic to suggest this developer can do anything to keep the application alive, to quote. It just would not happen, which is why Carla Homes are suggesting they have to go through the Section 84 process first. That is just common sense in property law terms. As far as timescales are concerned, an application before the upper tribunal would take 18 months to 2 years from start to finish. Each and every appeal, and there are potentially 2, could take between 18 months and 2 years. By way of example, the case I was just in, the Millgate case, which went to the Supreme Courts, that was 6 years from start to finish. Now, that's just one case, but that is the most recent high-profile case, 6 years from start to finish. And there are there's the hearing before the tribunal, and then potentially 2 tiers of appeal. So that's the point on timescales. The second point relates to whether the test as to whether the covenant is operating contrary to the public interest, which, as I indicated previously, is likely to be the main battleground. Mr. Beglan referred to my analysis of O'Reilly's application and suggested that I was deducing the wrong conclusions from it. My submission is that were you to read that report, you would accept that what I'm saying about it is correct. However, there's no need to take my word for it. There is a well-established textbook, Scammell and Gastovich on land covenants, which has a page in it summarising the relevant authorities, including O'Reilly's application as being some authority for the proposition I say it is. It also identifies another 8 or 10 cases. Mr. Beglan is adding the cases to the examination library, as I understand it. I wonder if I could please add this page of textbook. It's Scammell and Gastovich, sections 20.74 to 20.76. So it's 3 paragraphs, 1 page of the textbook, but it summarises the law. So there is no need really for us to reinvent the wheel because it's summarised there. And the authors of that textbook say, the tribunal has generally insisted that in the absence of evidence that there are no alternative premises in which the public interest could readily be met, it cannot be satisfied that the public interest is impeded by a covenant affecting the applicant's particular premises. So that is the position that the authors of the textbook state, and in my submission that is borne out by the cases, that the approach of the tribunal is to ask the applicant to prove that there are no alternative premises in which the relevant public interest could be met. And of course, it's the developer or the landowner making this application. The burden is on them. But as those cases show, that is what they have to prove, that there are no alternative sites. So as to whether it's a hypothetical question or not, I fully accept the tribunal will look at that question if asked to do so, but that is the test it has applied to date and can be expected to apply again. And if it doesn't, then there would be an appeal. The applicant, the developer and landowner must show that there are no other sites on which to put this housing in the local area. So my application is could I please apply to put that page of the textbook on the examination library as well?
Yeah, if I could, Mr. Beglin, is that something that could be done if that's sent through to the programme officer?
But sir, it could be done, but I do object to it being done. The point of looking through Miss Windsor's authorities in some detail in order to try and assist you today was to emphasise, as Mr. Malls also seemed inclined to agree, how important the facts are of these individual cases and how fact sensitive they are. And we say that's important when you're trying to assess how the upper tribunal might assess whether or not it's contrary to the public interest for the covenant to be maintained. In those circumstances, I'm afraid if just one page of a book which has citations to authorities put into the library, the matter is unlikely to end there. We have taken the time and trouble to look at the various authorities that have been put in front of us for the first time in Miss Windsor's advice, and we've dealt with that in some level of detail. We're entirely happy for you to look at those authorities, including the one that she cited for the support of this principle. But we do have to have a measure of proportionality, that this is you doing your best to work out whether there are reasonable prospects of something happening in another jurisdiction, and to do so on the basis of a proportionate evidence base. There have to be sensible limits to that, and so our submission is that we've now reached that point. And I do fear that if it's a sort of superficially attractive thing to say, well, I just want to refer to 3 paragraphs and a number of cases that are cited there. But as I say, the exercise of today demonstrates that, in fact, it's not forensically necessarily sufficient to leave matters there. And those cases may well need to be considered further. And indeed, there are a number of books that are written on this topic, and a number of principal books, not just, books around the edges, but there are a number of central practitioners' text, and Scammell and Gastovich is one of them. So no, we wouldn't be content with that as an approach, I'm afraid, in these circumstances.
Okay, I take your point, Mr. Beglin. I think I'm minded to revert to what I said before, Ms. Windsor, which was I'm content to take the authorities. I will familiarise myself with those and then take a view as to whether any additional notes that assist the examination. But I think that's as far as I can take it at this point. Have you got anything further to add, Ms. Windsor?
No, save that. My opinion, as I understand it, was circulated several weeks ago. Until this hearing, we had no notice of what was going to be said against that opinion. And so therefore, it's for that reason I'm now saying that the opinions expressed in my opinion are mainstream as evidenced by the textbook. So what I'm saying is that for the first time today, Mr. Beglin has queried the accuracy of a paragraph in my opinion, which it's his right to do, but it has not been done before today, or we could have addressed this issue. And my submission is that there is no substance in the criticism, as one can see from a reading of the case, but one can also see from a reading of the leading textbook, because the leading textbook summarises the authorities and the effect of them. And had I realised this was an issue, I could have cited all 8 cases rather than just one. But what I wrote was an opinion, setting out my opinion. And now Mr. Beglin is focusing in on one paragraph. And I'm simply making the point that there is a lot to be said, that could be said to back up that paragraph. And I don't accept Mr. Beglin's criticisms, and I don't accept that they're even fair, as could be seen from a reading of the textbook, which summarises the true position.
Okay, thank you, Ms. Windsor. So as I said, I'll reflect on that and deal with it in post-hearings correspondence if necessary. But we'll leave it. I've got a clear view on your position there. Who knows? Ms. Ashton.
Thank you, sir. Just a couple of points in response to comments made by the council at the beginning of this session, and also by Mr. Neame and Ms. Windsor. I mean, it now looks pretty clear that implementation of the development within the current timescales is not going to happen. Therefore, the council are now relying on somebody coming forward with an application for Milford Golf Course in the longer term, so that it gets put back into the latter part of the plan period. I have to say, again, there has to be a level of caution about that, and the realistic prospects of somebody actually doing that in the light of the planning history of this site now. Everybody is aware of the situation with the covenants of Milford Golf Course. They're aware of the strength to which they are being protected. They are aware of the planning situation as it stands in Waverley. And they will also be aware of the fact that actually the planning system has changed since the outline consent was granted. So there are no guarantees that you'll actually get 190 units on Milford Golf Course now. I think the realistic situation is one that we have proffered before. And I would go back to whereby you look at what else could be provided for within Milford to address the requirements of the local plan part 1. You don't need to do that through a review of the local plan part 1. You can do it through the local plan part 2. You've already partly done it by virtue of what happened through the Reg 18 strategy and the asterisk sites being found to be acceptable then, but then subsequently discounted. And my submission remains, if you look at my Appendix 1, there are options available to the council, and I would respectfully suggest that they actually do look at them and give them some detailed consideration rather than just dismissing them. Thank you.
Thank you, Ms. Ashton. Mr. Roberts.
Thank you, sir. If I could just briefly explore a separate point, really, which is when we consider developability, when we consider what a developable site is, we distinguish typically between sites that could come forward within 6 to 10 years and those sites that might come forward within 11 to 15 years. So you have almost a first and a latter part of what you could call a developable period. So what I want to understand, perhaps from the council, and in view of what we've heard today, and in view of the statements that you've received, is why the council, in contending that the site is developable, why has it opted to identify the site within the 6 to 10 period rather than the 11 to 15 years, other than perhaps simply because that would go beyond the plan period, and therefore there's no interest in doing that. But I make the point really with reference to the planning practice guidance, and specifically paragraph 20 of the housing supply and delivery section of the guidance. And that draws a distinction between the degree of certainty required to place a site which is defined as deliverable within either of these categories. So for a 6 to 10, if you're within the 6 to 10 year category, there's a relatively greater degree of certainty required when compared to putting it into the 11 to 15 year capacity. And that's because the PPG points to wanting a pragmatism in approach, but still requires a greater burden of proof within that middle period. So on the basis of what we've heard and on the basis of the evidence from the council, it's not really clear what justifies, I think, the council's placement of the site within this category. There's a clear lack of specific written evidence from the promoter or the developer. It seems to me a high degree of uncertainty regarding the covenant, however that may play out, particularly the timing of any application to the tribunal and of course its outcome. And as I think Ms. Ashton has explained, there would be a requirement for new planning applications to come forward in order to address the current trajectory presented by the council. So it seems to me that if this site is to be regarded as developable at all, and I don't think it necessarily should be, then it would seem to me logical that it's placed within that 11 to 15 year period, which requires the least degree of certainty. And it seems to be uncertainty coming from a lot of different directions for this site. And as I say, other than it will push it beyond the plan period, I can't really see why the council's reached their conclusions that they have. And as others have said, it seems very likely to me that site will fail to come forward within the plan period, and LPP2 is an appropriate location to consider the asterisk sites and revisit the Reg 18 position in order to ensure that housing needs are met fully within Whitley Milford. And I would respectfully submit that my client's site could play a role in that as we've described. Thank you.
Thank you, Mr. Burden. You're muted, Mr. Burden. Still can't hear you. Okay, I'll take Mr. Chapman first, then come back to Mr. Burden.
Thank you, sir. It was just really to reiterate what the other representatives have just said, really, that we have an opportunity in the local plan part 2 for further sites to come forward to seek to mitigate the possibility that Milford Golf Course isn't going to come forward in the timely manner that's anticipated. But I also, and these are points that we've made previously, that we're not getting a great deal of comfort from Waverley that it is seeking to provide new homes, sort of full stop, really. Someone said in one of the hearing sessions about the can being kicked down the road, and we're looking to address the outstanding lack of housing land supply under local plan part 1. But here we do have an opportunity to meet the housing land requirement, but for whatever reason, Waverley just seems to be reluctant to want to do this. And as I say, it doesn't really fill us with very much confidence that when it comes around to local plan part 1, that there's going to be the same sort of attitude regarding homes coming forward or land for new homes coming forward again. That's it, really, sir. Thank you.
Thank you, Mr. Chapman. Mr. Burden, try again.
Can you hear me, sir?
Yes, yes.
Perfect. I think Mr. Beglin's been playing with my microphone. I jest. Just a couple of points. Lots been said this morning. I wasn't at the last session, so I'll try and keep this brief. Obviously, not specific about the site in question, but broader ramifications. And we've heard a lot about what Inspector Ball said at the LPP1 examination. And of course, LPP1 was assessed against the 2012 NPPF. I don't obviously need to tell you that the tests on deliverability and identification of a developable site are very different now to that set out in Annex 2 of the current NPPF. Just to follow on from that, sir, and I'll take the liberty of referring to Mr. Neam's previous statements on this point, because he very helpfully has highlighted the number of times that this council have been found to be lacking a 5-year supply. And I've made this point in an earlier hearing session, but I think it's fair to say probably pretty much from the adoption of LPP1, they haven't had a 5-year supply. And this site comes up pretty much every time, I think it's fair to say. And I think almost without exception, your colleagues at each Section 78 appeal have found this site wasn't deliverable in the 5-year supply. And obviously, they haven't had to make a decision or judgment looking forward, but it's very clear. I mean, we've had 2 hours of a legal debate about this morning, sir, that this site is troubled. Planning Commission will lapse next year. Doesn't seem like it's going to be capable of being implemented by next November. We've heard the quote and seen the text from Carla in terms of their approach. So there really is no certainty we're going to be able to move this site forward. And you've been asked a few times, so well, and I think you've indeed asked the question, what is it for you to do about this? And the reality is, I think we all recognise you can't rewrite LPP1. And that's fine, that allocation probably does have to stay. But what I think myself and other participants are asking of you, so, is to make sure that that shortfall is dealt with in LPP2. And we've had quite a chat previously about the urgent need to get LPP2 moving, the comments from Inspector Ball previously. He was incredibly explicit about the extent of the shortfall. And no doubt we'll touch on this a bit later, so when we get onto other sites, and Dunsfold has been notably absent so far, unsurprisingly, but it will come up later. But of course, we're also facing into this, the LPP1 plan being 5 years old, and the strategic plans policies therefore being over 5 years old, and standard methodology kicking in. And in effect, as you probably are aware, that the housing requirement would hop up to, based on the latest numbers, up to 744 dwellings per annum. So about 150 more per annum over and above what LPP1 is supposedly planning for. And obviously paragraph 74 of the NPPF deals with that. What we do know, sir, is we're thousands potentially of homes short in Waverley over the remainder of the plan period, and it is necessary for LPP2 to deal with it. We can talk for hours, and no doubt we have been talking for hours about this particular site, but this is just one of many examples of sites that are simply not deliverable over this plan period. And I would ask you, sir, to give careful consideration as to how we address that. And I think we are going to need to look at new sites, not just in this geographic area, but wider afield across the borough. I'll leave that for now, so it's creeping on to lunchtime, so I will wait for this afternoon.
Okay, if I could go now to Mr. Beglan for final responses, particularly on the question I posed on Milford and Whitley, please.
So yes, one point on timetabling, but before we get there, in relation to the timetabling, you asked a question earlier, and we did give an answer, both in relation to the delay that an application to the tribunal is likely to cause in the council's view, and also that it's entirely sensible in terms of taking a strategic site forward for a developer or promoter to wait until they have their planning permission in full in place before making the application to the tribunal. And that's the position that the owners and potential promoters are now in. So that deals with the issue about timetabling. It would not be a sound basis, I suggest, to consider the issue of timetabling on the entirely hypothetical consideration that there might be an appeal from what the upper tribunal does to the Court of Appeal, or thereon to the Supreme Court. You could say that about any case, and that's just not a proportionate way to address those issues. So again, we invite you to bear that in mind. In cases where the subject matter is of sufficient importance, there is also the ability potentially to split issues at the tribunal or look for abridged directions in relation to that. But none of those issues, in the sense of getting the timing of the covenant resolved, are going to be time critical, because the authority has now moved the site away from a suggestion that it is deliverable to it being a developable site. And going therefore back to the question, sir, that you've asked about additional provision potentially in the locality, if the correct approach, as Mr. Burden seems to accept, and I suggest is plainly right, that the strategic allocations need to remain within the consideration of LPP2 so that it can properly fulfill its function, then if there are to be, as I think one of the other hearing statements refers to, a suite of other allocations, then the natural consequence of that is going to be, and one has to face up to this reality, that the distribution across the towns and villages that was very carefully considered, and that Inspector Ball plainly thought was appropriate, and we looked at this in much more detail last time, so I don't trespass on that point anymore. But that is the necessary corollary of what's being suggested here, on the basis that most parties seem to accept, and quite rightly so, that the strategic allocations can't be disturbed now. So those are my observations in relation to that point about the distribution of housing. I'll just look to see if colleagues have anything they want to add on that point. So no, nothing further from us on that point. Thank you.
Thank you, Mr. Beglin. I think if we could just before we move on to the lunch break, we could just start on the discussion about the requirements for Hazelmere. So the council's matter 2 statement indicates that some alteration should be made to the proposed main modifications relating to Hazelmere's requirement in local plan part 2. So could you just outline the reasoning for that, please, Mr. Beglin?
Yes, sir, of course. So in terms of the Hazelmere requirement, when we were busy updating the housing trajectory, we reviewed the outstanding planning permissions data that was used for that. And we found that there was a case of double counting against one site, which I've detailed in our response to the matter 2 questions. And for that reason, we've removed the double counting, and that has adjusted very slightly the Hazelmere requirement. And I've included the updated figures in table 1 in our response to matter 2.
Thank you. I've got no further questions at this juncture on that requirement, as it's set out in your statement. But has anyone else on the call got anything further to add on that specific point before we break? Okay, I'll take that as a no. But I suppose we could take some quick questions from point 3 of my agenda, which is the justification for the anticipated rate of development, and some of the responses I've received to questions 2 to 5 next, just before we break. So taking Milford and Whitley first. So I posed a question about the application for SANG, and I got an update on that position from Mr. Wood. I wonder if there's anything further to add at this point, Mr. Wood, on that SANG application.
Thank you, sir. Nothing further to add from the hearing statement, other than we do now have a new case officer, so hoping that things will start progressing a bit more positively now that we have an officer allocated to the application. But note that there remain no objections to the application we're aware of, and I think since the hearing statement there has been a further consultation response from the SANG officer, who we are liaising with to resolve the future management of the SANG, which is one of the points that Natural England raised in their consultation response.
Thank you, Mr. Wood. And could you remind me how many dwellings would the SANG provide mitigation for?
I believe the SANG has capacity to provide for, I think it's 236. I may just have to double check that figure and then come back to you.
Thank you. I was looking back over hearing statements. I couldn't find a specific figure, but yeah, if over the break, if you can confirm.
Yeah, I can. Yeah, and I can confirm what that number is.
Thank you. Thank you, Mr. Wood. I've got no further questions on that. Okay, I think there's some more substantive matters that I want to go in next on some of the Hazelmere sites, but I think I'm minded now to leave it until after the lunch break so we can get a decent run at it. So if we break now and come back at quarter to 2. We could do that. Would the Zoom link allow us to do that, Mr. Beglan, do you know?
So yes, it does.
Yeah, thank you. So just a reminder, so that this there's a separate Zoom invitation, I think, for this afternoon session. So if you could close and exit from this session and log into the other link that Charlotte's circulated in good time to start at quarter to 2. So this hearing is adjourned until then. Thank you.